Thank you very much, and thank you, Nina, for inviting me to speak today. I was a willing victim for the occasion. I was in the audience full-time at the first conference, and I took the opportunity of being in Washington to go and see Nina and have a chat with her before the conference. And if you go to the IRS building in Pennsylvania Avenue in Washington, above the door as you walk in stone, concrete, whatever, are the words of Olive Wendell Holmes, who was perhaps one of the most famous Supreme Court judges in the States in the early part of the 20th century. And the quote is, "Taxes are what we pay for a civilized society." So that's what we're trying to achieve. But there is, and I'll start the story, if I may, in the aftermath of the Second World War and the setting up of the various global organizations, one of which was the United Nations. And the United Nations in the 1940s had the Universal Declaration of Human Rights, which doesn't specifically mention tax, except to the extent that everyone is said to have the right to own their own property, and no one should be arbitrarily deprived of that property. And then the Council of Europe was set up in the late 1940s, and they produced one of the most famous documents that they have produced is the European Convention of Human Rights, which states everyone is entitled to the peaceful enjoyment of his property, and no one shall be deprived of his property except by the rule of law. But there is then a protocol which was introduced about a year later to the effect that taxes were an exception to that rule and that people could be deprived of their property for the purpose of spending money on public goods, so infrastructure, health, schools, education. But there's a tension which is pretty self-evident then, that actually the states are very powerful, the individual is not necessarily, certainly not as powerful as that, and you need to have some means of ensuring that the taxpayer in this case is not overruled, is not subjected to unfair pressure, has his rights maintained by whatever system you introduce. And it's interesting that in the panel and our moderator, we've got lots of different approaches to the way you safeguard the interests of the taxpayer. So it's in law in the Netherlands. We have a statutory provision in the UK saying we have to have a charter, but there is no provision about what the charter shall contain. And we now have different rules in the United States and different provisions in Australia. So there are different ways of getting to an answer. And one of the things that has happened since the first conference at the end of 2015, and just thinking about this morning, I was instrumental in rewriting the UK's charter, which was published in January last year. The European Commission has finally, in November, ended a 3 or 4 year period of work and produced a taxpayer code. The Inspector General of Taxation in Australia has produced a review which he published in December about taxpayers' charters in Australia and looked at the experiences in other countries, including the UK, US and Canada. And the IBFD, which is going to be the host of the third conference, has produced a piece of work which followed from the International Fiscal Association's Congress in 2015, and it set up an observatory of taxpayers' rights, and it did a piece of work which you may have seen, which is the practical protection of fundamental taxpayers' rights, and I wrote the UK chapter for that. So I've been involved in this space for a little while. And also the European Union codified the way in which it had protected rights either in the Court of Justice or in directives, and it came up with a Charter of Fundamental Rights which got statutory legal force in 2009. So there are lots of different organisations which have been involved in this area. So going back to a very, very long time, King John in the early 13th century was oppressing his barons, and they got him to sign. It wasn't actually signed, but they got the Magna Carta was agreed in 1215. It quickly was overruled by the Pope at the time, so it didn't last very long. But it did act as an iconic sort of reference point for people subsequently that were trying to restrict the power of the authority of the king, the powers that be, to oppress their citizens. And if you were in London in 2015, the British Library had an 800th anniversary exhibition, and there are 4 copies of the Magna Carta, and they were all on display for a few days in the British Library in Euston Road in London. And Lord Denning, one of our most famous judges of the 20th century, said that Magna Carta was the foundation of the freedom of the individual against the arbitrary authority of the despot. And that battle has continued forever after. And Philip Baker is in the audience today, said of tax charters that they're a short, accessible statement of the basic rights and obligations in dealing with tax authorities. And they've been around probably for about 30 years, in my estimation. We had a charter in the UK first in 1986, and that was largely for mainly negative reasons, that the Inland Revenue, as it then was in somewhat disarray. They weren't able to answer their post in any meaningful time frame, and they were throwing post away rather than answering it. It wasn't a very good way of dealing with the taxpayers' sort of concerns. So the then chairman of the board of Inland Revenue introduced a charter, much to the not horror, but it was not supported by the people who worked in Inland Revenue in those days, so I'm told by people who were working there. But nevertheless, that was the first charter. And then when we had a new government in 1990, John Major, who was our Prime Minister, wanted to make sure that we'd had a lot of privatisation, a lot of public authorities had moved into the private sector, but the Prime Minister wanted to make sure that the citizen, the UK citizen, would understand what any particular public authority was supposed to be doing, and would also understand what rights the individual had of redress if the public authority didn't do what it should be doing. So we had citizens' charters, and we had a second version of the Taxpayer Charter in 1991, which was more recognisable as the sort of charters that you'll find around the world today. And then Tony Blair became the Prime Minister in 1997, and he had a different perception of how you measure the performance of public authorities. It was all about targets and other ideas. And the charter, our UK charter, disappeared from view, it's fair to say. I did have an argument with, it had by then become HM Revenue and Customs, as to whether the charter was still in existence, but it was pretty clear to me that it had disappeared. So we had a new charter, and that was because when we had joined together the 2 revenue departments in the UK, the Inland Revenue and Customs and Excise, to form HM Revenue and Customs in 2005, and we'd reviewed and changed the powers of that new authority, the HMRC decided that it would be only reasonable that we should now seek to protect the interests of the taxpayer against the extra powers that the authority had taken to itself. So we had a debate, consultation in 2008, 2009, and by that stage, HM Revenue and Customs was also paying out money as well as collecting money. So it was an organ of the government's social security programme. So it was paying out quite a lot of money as well as receiving a lot of money. So instead of calling it a taxpayer's charter, we called it your charter. But also, in debating it and making it a statutory requirement that there should be a charter, Parliament said that there needed to be a committee which would oversee the work of HMRC in protecting the taxpayer. So a Charter Advisory Committee was set up, and one of the conditions that Parliament insisted on was that there should be a majority of non-HMRC people as members of that committee. And I was a member of that committee, and then for 3.5 years I was the chairman of that committee. And then in 2006, as I mentioned earlier, we had a new charter. I was responsible for organising what finally became that new charter, and I have been for the last 15 months an advisor to the new Charter Committee, and I'm just about to stand down. So I've been fairly involved at the centre of what the UK's activities in charter work. So we'll look at approaches to a taxpayer's charter. So the European Commission has come up with a model of the European taxpayer's charter. The OECD, and I think one of the things which has happened is that because the UN wasn't very active in tax work in the post-Second World War period, when OECD was founded in 1961, it took over the responsibility for the tax system and principally got involved in double tax treaties and laterally transfer pricing. And it wasn't really focusing on taxpayers' charters. So although it's kept an eye on what's going on, it hasn't really been at the forefront of work in this area, I would say. Jeffrey may disagree with me, and he will tell me afterwards in the break. But I think the drive has been elsewhere. But and then the organisation of which I am a member, the Fiscal Advisors in Europe, produced a model taxpayer charter. So we did a survey, and we produced this last year. And it's more than the principles which should be enshrined in a charter. It's also about the sort of parameters of a tax system which are going to provide adequate safeguards for the taxpayer. And that's available on their website. So turning to the European Union, my slides are in a slightly different order, so I will speak. So the CFE, the Model Taxpayers Charter, it basically set out 10 rights and 10 obligations, which are displayed on the screen. And you'll find, although there's a lot of disagreement about how you actually make it work in practice in individual countries, there's a fairly common sort of theme that when you look at actually what is in individual countries' taxpayers' charters as to what they say. So the authority must act with integrity and be fair to the taxpayer. You need some certainty for the taxpayer. You need a system which actually works, which is efficient and effective. If it doesn't work well, then that's to the detriment of the taxpayer. If things go wrong and you can't resolve them in a reasonable way, you do need to have some mechanism by which you can appeal against the decision of the authority. You need to make sure tax systems are inevitably very complicated. We live in a complicated world, and you need to have some appropriate assistance from the authority so that you can understand what it is you're supposed to do and how you're supposed to do it. And in the majority of countries, it's very important that the affairs of the individual taxpayer are kept confidential and are not put into the public domain. And clearly, you need to have a system which ensures that you pay the correct amount of tax. You don't want to pay more than you should, and you don't want to. The tax authority doesn't want you to pay less than you need to. And representation. I work for I'm an organisation which has tax advisors amongst its members. So you need to be able to be free to appoint somebody to help you to deal with the tax system. You need to have the ability to have somebody to represent you and to explain to you what the tax system means and what you need to do. And you also need to have the tax authority needs to believe that you are being honest, unless self-evidently you are not. So the UK Charter, it's going to be covered in the next presentation, so I won't go into that. And it says similar sorts of things as the CFE Charter, so I won't go through those rights. And there are some questions about charters. So should it be on a statutory basis? We just in the UK have a provision which says that the HMRC must aspire to reflect the principles in the Charter. And we have a committee, as I've mentioned, to try and ensure that that is the case. And at the moment, I think we're in, if not a sweet spot, we're at least in a position where I think the UK authority is very keen to be seen to be acting in accordance with the Charter and doing everything that it can to make sure that it works in practice. There have been debates in the past about whether you should include obligations as well as rights. I've always been pretty clear myself that charters need to be both set out the rights of the taxpayer, but equally give them obligations as well, because the majority of countries now have self-assessment. It's down to the individual to understand what they're supposed to do in the system and to do it. So they do. If they don't have some obligations, then they won't get the system won't work. Whether the rights and obligations are linked, I don't think they are. I think there are two sides of the coin, but they're not. They're not inextricably linked. You don't get rights because you have fulfilled your obligations, I don't think. But I think the most important thing about a charter is the core of the tax system, which is not disputatious, I don't think. It's just individuals trying to make sure that they do what they're required to do, to fill in the forms they're required to fill in, to pay the tax if there's an extra payment of tax to be made. And there needs a culture of understanding between the tax authority and the taxpayer. So in the large business world, that has become characterized as cooperative compliance, that there is a genuine and often robust relationship between the tax authority and the taxpayer. And I think something like that needs to be replicated in the private, individual sector of the tax system. And the UK authority tells me that they collect pretty automatically about 90% of the tax that needs to be paid in the UK. About 3% needs a bit more of an effort. So there's a bit more of a dispute about that. And about 7% is what we call our tax gap, which is not currently collected. But most tax systems depend upon compliance, good working relations between the tax authority and the taxpayer. And I don't think you can encapsulate that in law. And if you do, it's not a very good system if you have to then take legal action to ensure that the authority does what they're supposed to do. So I think there's a behavioural inward to taxpayers' activities and their relationship with the tax authority, which I think is crucial and key to a good tax system and a system which supports the rights of the individual. So that's all I had to say. I think, it's interesting that, and I'll just end on the OECD. They produced a survey of legal systems in 1990. They think there isn't a physical copy of it, but I've got one. So there you go. I bought it secondhand from a library somewhere. But they have, one of the things they said, so it's almost 30 years ago, and it was talking about changes to the tax system. And it says another major change is in the relationship between the taxpayer and the tax administration. Many countries are seeking to improve the service provided to the taxpayer, in part because modern tax systems require increased cooperation from the taxpayer if they are to operate efficiently, and also as a result of changing attitudes to the role of the tax administration vis-à-vis the taxpayer. This cooperation is more likely to be forthcoming if there is mutual trust between the taxpayer and the administration, if the taxpayer's rights are clearly set out and protected. And for the next 2 days, we'll be talking about all the nuances of that and how we actually ensure that that does actually happen and what are the challenges that we are facing. And I think we're facing, the two challenges that I see facing us is that we're all going to have much more digitalised systems. We're all going to be much more in the crosshairs of the system than we are at present. We're not going to be outside the system making an annual return and that's it, and paying our taxes. We'll be right in the middle of the tax system. And I think how that is dealt with by the tax authorities and how that plays out in terms of taxpayers' rights, I think will be interesting and challenging for us. I think the other major change is that the big data that we hear about, the work that the OECD has been doing in terms of getting transfers or exchanges of information, particularly about financial accounts, the Common Reporting Standards gets going later this year. The US has had FATCA, the Foreign Accounts Tax Compliance Act of 2010. There's going to be a lot more information available, transferred to tax authorities, and they're going to know much more about the taxpayer than they currently do. And I think that's both, that may make the tax system easier, but it may make it more threatening to the taxpayer. And I think those are the two sort of major changes that I can see that are potentially going to cause difficulties, threats, opportunities, whatever you choose to call it. So I think wisely Nina has told us that she's already planning for the third conference, and she's got the fourth sort of in the planning stage for Minnesota, if I remember rightly, in 2019. So we're going to be on this. This is a journey. We've been sort of 30 years on it so far. I think there's plenty more to go. There are plenty of differences between the different countries. There are already quite a lot of challenges which you'll hear about for the next 2 days, but I hope that's been a helpful introduction to what you'll hear in the next 2 days.
Thank you very much. Thank you very much, Ian, for giving us the framework for taxpayers' rights. I think the UK and the Netherlands, they share experiences with the concept of cooperative compliance. And you also mentioned the importance of culture with respect to taxpayers' rights. Well, my experience is that the tax administration always says, well, cooperative compliance can only work if you consider a taxpayer as a kind of friend, as a kind of colleague. So you don't need rules for that. But you understand that doesn't work, because you can only always come into kind of conflict. And for this conflict, you need rules. You need rules for situations in which you disagree, in which you want to go to court. And then you cannot have the argument of the government saying, well, you said we were friends and now you're angry. No, that's not the way it should work. Thank you very much. And now I give the floor to Elaine for the UK experience.
Thanks. Good morning, everyone. So, my name's Elaine Ben. I've worked for HM Revenue and Customs for around 3.5 years now, and prior to that, I worked for one of the big spending departments, the Department for Work and Pensions. So it's a great pleasure to be working for one of the big departments which brings in the money which funds those taxpayer services. I'm the Central Customer Director, and what that means is it's my job to make sure that customer needs and customer perspectives are put at the centre of the tax system, both in terms of the way in which we transform that system and modernise it, but also the way in which we run it. So I have a big behavioural and customer insights team. We work alongside customers as we design systems, and we are increasingly trying to make sure that we bring customers alongside us and we look at their life events and their business events, and we design around those rather than the detail of an individual tax process or an individual tax product. So it's a fantastic job to be able to speak for customers, and part of that is that I manage the Charter and the Charter Committee, which Ian referred to. So I thought it would be interesting to try and bring the Charter to life a little bit. So rather than talk about theory, mine is a talk about the practice of running a Charter in action. So I will just very quickly touch on the mission and goals of Revenue and Customs, a little bit about the customers that we serve, and then talk about the way in which the Charter has been used in a couple of ways to shape the Revenue and Customs approach going forward, and a bit of reflection on what's working well for us and what might be even better. So as in common with most tax authorities, of course, as Ian said, we are a tax, a payment and a customs authority. So we pay money out as well as bring money in. So we collect the money to pay for the UK public services. We help families with targeted financial support so that it is better to work than be on benefits. So we pay out support for families with children and for low-paid families to help them support their families through working and giving them a little bit of extra money to supplement their wages. We help the honest majority to get their tax right, and we make it hard for the dishonest minority to cheat the system. And we do report to Parliament through our Treasury Minister, who oversees our spending. So I think that's probably a fairly common theme for many of the tax authorities around the world. But HM Revenue and Customs loves its facts and figures, so I thought I would share a few with you today. We're actually one of the UK's largest organisations, so many of our own staff pay tax. Indeed, many of them receive tax credits because the vast majority of our staff are in rather junior grades. They sort of make the tax system work. So we have around 57,000 employees. We support around 45 million individuals. And as Ian said, the vast majority of our tax comes in automatically. As you get paid, we already take the tax and national insurance contributions from you. You don't get much choice. It's taken from you before you are paid your net salary through your employer. So most of the tax revenue comes into us automatically. We also deal with around 5 million businesses, 4.8 million businesses. Many of those are the big businesses, but increasingly the self-employed, small businesses, the sharing economy is a growing factor of our tax system. So our interactions with our customers are also at scale. Around 60 million phone calls a year around 15 million letters. But of course, we're getting into the digital age now. We have a business tax account and a personal tax account where you can view your tax affairs online in much the same way as you would with your tax. So increasingly, I think around 9 million people now are opening up their personal tax account. We only recently launched this a year or so ago. So for us, the shift is from dealing with traditional post and telephone into the digital tax account. And overall, we collect around £500 billion a year in tax, but we also, as I said earlier, we pay out tax credits and child benefits to large numbers of our customers. So that's us. In a word, we deal with people, just about every single person across the UK, from cradle to grave, really, through the child benefits, through till end-of-life support and the like. We are a non-ministerial department that's intended to protect us and make sure that the tax system is impartial and that the policies that we have, generally speaking, survive the sort of the political influences of the day. So into the Charter now. I think this ticks most of the boxes that Ian was referring to when he talked about all of those studies into the different kinds of elements of charters and the best practice. So these are some headlines, and as you will see, it equally sets out rights, what you can expect from us as a tax authority, but it sets out obligations too, what we expect from our customers. And the headlines are underpinned by broader statements to bring them to life a little bit. So, for example, the first one is around respect. We will respect you and we will treat you as honest. So we'll treat you even-handedly with courtesy and respect. We'll listen to your concerns and answer your questions clearly. We'll presume you're telling us the truth, unless we have good reason to think otherwise. So we take each of these statements and we give our taxpayers a little more information. So, for example, we also talk about providing a helpful and efficient service. That's what our customers can expect from us. So we'll help you to understand what you have to do and when you have to do it. We'll deal with the information you give us quickly, efficiently, and we'll keep any cost to you at a minimum. And we'll put any mistakes right as soon as we can. So as we go through each of the rights and the obligations, we try and explain this in simple terms to bring it to life for our customers. Because when we reviewed the Charter, one of the things that we wanted to do was to make it an outward-facing Charter, to make it equally balanced between rights and obligations, but to be able to bring it to life for people in plain English, in simple terms, so that people could challenge us if we weren't living up to our rights, to your Charter. So you will see that we're offering that we will act professionally and with integrity, that we will provide security for customers' information and respect their privacy, that we will allow them to be represented, whether that's because they have complex tax affairs, they just feel a little bit more reassured in dealing with the big beast of revenue and customs if they have someone alongside them representing them, or if they have particular needs. They may be disabled, they may need a little bit of help because English isn't their first language in dealing with the tax authorities. So we accept that people can be represented. And we also say that we will handle complaints quickly and fairly. And I'm going to touch on complaints in a little while because that's one of the ways in which we've brought the Charter to life, and I'll give you an example of that in a moment. But we also make clear that we will tackle those who bend or break the rules, because there's this great British sort of sense of justice running through our tax system. People expect us to chase people who don't play by the rules and who don't pay their fair share, quite rightly. Depending on whether you believe what you read in the media, at the moment in Revenue and Customs, I think that most people trust us as an organisation. We have a pretty good reputation for actually administering the tax system fairly in the UK. People may occasionally argue with us. They may think that we're a bit tougher on the little man and that we let big business and international business off. They may grumble that our service isn't perhaps always as quick as they hope it might be. Although in the last sort of year or so, our service to customers has really massively improved and bears no relation to those days that Ian referred to earlier. So if you want to contact us, you can get through on the phone very quickly indeed, or you can deal with us online, whichever way suits you. So generally speaking, the UK taxpayer, and we do surveys, of course, from time to time, believes that HM Revenue and Systems can be trusted to run the tax system. But just a little bit around obligations too. We expect customers to be honest and work with us to get things right, and to make sure that they have reasonably accurate records, that if they have a representative who deals with their tax systems on their behalf, they have to make sure they know what information and payments their representatives are sending us, so, and that is accurate and comes in on time. So that's our charter. As I said, it covers most of the territory. And to make sure that we actually deliver on that charter, we have a charter committee. It's a subcommittee of our board who run the revenue and systems. So it is their role to make sure that we deliver against your charter. So they advise the board on whether our strategies, our policies, our practices and services and the way in which we measure those services are effective in relation to the charter commitments. They provide recommendations on improvements, and they provide an assurance that your charter is being delivered in line with the undertakings given to Parliament. So each year an independent annual report is published which sets out how Revenue and Customs has performed against its charter obligations. And as Ian was saying earlier, the Charter Committee is made up largely of customer representatives and non-executive directors of Revenue and Customs. So our chair of the board attends, and people like me and our Director Generals attend, but the vast majority of people sitting on our Charter Committee are from outside HM Revenue and Customs. They are representative of the customers that we serve, and we refresh those Charter members every 2 or 3 years, so that as those Charter representatives get to know a little bit more about Revenue and Customs, sometimes they can sympathise with our problems, sometimes they can understand why maybe it's quite hard to live up to those Charter commitments. But we want to keep the challenge there. We want to keep them bringing in new perspectives and bringing best in class from outside Revenue and Customs and outside government. So from time to time we refresh our charter membership. So if you like, they keep giving us a tough challenge and stop sympathising with our problems. It's their job actually to push us to be as good as we possibly can be. Just a little bit about what customers can do if they disagree with Revenue and Customs. They have a whole range of options available to them. And I won't talk about these in any depth other than to just touch on complaints in a moment. So if you are a taxpayer, you have the right to complain about the service that you have been offered. You have the right to ask for your case to be reviewed and reconsidered if you don't agree with the decision that we've given you. You can go to an appeal or a tribunal. You can get involved in what we call alternative dispute resolution. It's just a way of bringing parties together with mediation to try and resolve complex tax cases. And of course you can go down the route of sort of litigation. So there are a whole range of ways in which we hope that you don't have to, but you can, if you wish, disagree with what we're saying about your tax affairs. And one example of the Charter in action is around complaints. So part of our Charter commitment is that we will deal with complaints quickly and fairly. And we had an ambition, a complaints ambition, which set out the way in which we wanted to do that. And it served us pretty well, but it came to a review period where we felt it was a little bit inward-looking. So the Charter helped us to refresh that complaints ambition, the statement of how we will deal with complaints from our customers. So just a little bit about how complaints work. Of all of those millions of interactions we have with customers, typically in a year we get around 80,000 complaints from customers. Around 80,000. And the vast majority of those are dealt with satisfactorily. Customer may not agree with the outcome, but they have decided at that point that they won't pursue their complaint any further. So the vast majority, around 92% in the yellow box, get dealt with by a customer complaining, and somebody independent, somebody else in HM Revenue and Customs will take a look at that case and see whether it's been dealt with satisfactorily. If a customer isn't happy, they can ask for someone else to take a look at that. And again, someone else in Revenue and Customs takes a look. But we also then have an adjudicator, an independent adjudicator, who will look at complaints from an entirely independent perspective. And she gets around 1,200 complaints a year. So of those, most customers either have their complaint upheld or overturned. So at the moment, the adjudicator upholds or overturns around 40% of those 1,200 cases. So they hold Revenue and Customs to account for dealing with complaints fairly, either in accordance with the regulation or with what you might call some empathy. So the adjudicator can uphold a case if she thinks we have either not followed the rules and regulations or we haven't considered the customer perspective. So maybe we were right in law, but the customer was in a position where either perhaps the system had been a little bit unfair to them, or they couldn't afford to repay, or whatever, their personal circumstances hadn't been taken into account. So the vast majority of cases are dealt with through internal systems. Cases then go to the adjudicator, she upholds them, and then eventually you can go to the parliamentary ombudsman, who upholds around 10% of the complaints against us. So we're quite open and public about complaints, and we said we want to be the best in Whitehall. That was our complaints ambition. We want to be the best at handling complaints in Whitehall. But when we learned from our adjudicator, when we discussed this with our charter and our people, we decided that wasn't a terribly ambitious thing to be. Actually, we were pretty much the best at handling complaints across other government departments. But what the Charter Committee made us do was think about comparing ourselves with industry. How would we compare with best in class outside government? That was a much more ambitious thing to be aspiring to. And actually, when we shared that with our staff, they agreed. They didn't want to be the best in class in Whitehall. They wanted to be the best across industry. They wanted to look at big institutions like, Marks and Spencer, and Virgin and other big companies who we thought in the UK, generally speaking, offered a great service to their customers. So that resonated with us. But what the Charter made us do was really reflect on, are we learning from those complaints? So our new Charter gives a commitment to really learn from complaints. What is it that causes customers to complaints? Where are the pain points for our customers? That's the thing that they said we should really put the focus of our attention on, learning from complaints and tackling the root causes in the system which cause pain and anxiety for our customers. That's just one way in which the Charter influenced the way in which we deal with complaints and the way in which we operate. So very briefly, I just want to reflect now on what works well for us about our Charter and where we could be even better. So I think our Charter works pretty well with the culture of the UK. I'm sure we'll discuss this a lot over the coming days as we compare different systems. It fits with our sort of tradition in Parliament. It fits with particularly the annual report where we have to, where we get that independent sort of assessment of how we're doing. It fits with the way in which the public views HMRC. We have recently refreshed the membership and brought in a much broader range of customer representatives. And the fact that we are going to refresh that membership every few years, I think, will be, for us, refreshing in terms of the challenge that they keep bringing to us. So we've now got a much broader range of our customers represented around the table. It has a very high profile in HM Revenue and Customs. So to get the chairman of the board along, to have membership of our Director Generals, this allows our charter representatives that to challenge the executive. We bring topics to the Charter Committee early in the formation of policy or implementation, so the Charter representatives are able to shape the way in which we do that. So recently we have published some consultation on how we digitise our tax system. And the Charter Committee reviewed that. They had presentations from the people who were developing the plans, and then they published their own response to the public consultation from the Charter perspective. So I think that shows that they are able to influence the way in which the executive operates. And I mentioned earlier that independence, so that that is once a year they get the opportunity to publish their own report. My team help them by pulling together the words, but the words are actually the Charter's own. How can we improve? I think our Charter will be more effective as a committee if they focus on fewer things and they get into them in more detail. Our latest Charter Committee has been operating for a year, and the first year they've largely been getting their heads around the enormous complexity of the tax system and how we operate. And they wanted to look at everything. They were interested in exploring everything at first. But what that meant was we were having to bring them up to speed on a huge range of things, and they were just skimming the surface. So what we've agreed for the year ahead is that they will tackle fewer topics, but they will get into much more depth. And they will visit the front line, they will understand from sort of cradle to grave, if you like, how a process works and how customers are affected by those processes. So initially it was a bit broad-ranging. If we narrow it down, it will work better. A better balance of discussion between rights and obligations. I guess it is the natural instinct of a Charter Committee to focus in on rights. But one of the most difficult things we do is to help customers to keep their tax affairs right. So I think we can benefit enormously if the Charter will help us focus in on how we support people in their obligations as well. We need to do more to embed the Charter right across the organisation. So people like me are passionate about it. I have Charter champions whose job it is to push that out across the organisation. But Revenue and Customs, as you saw earlier, is a huge organisation. And so we have a challenge at getting every single one of our members of staff to embed the Charter day in, day out in the way in which they deal with customers. So there is much more for us to do there. And then finally, keeping our discussions evidence-based. We all tend to relate the tax system to our own personal experiences and those of our family. And there is a tendency for some of the discussions to be based on those anecdotes. But actually, we always have to reflect that maybe we're not typical of the taxpayers at large. So keeping our discussions based on the evidence of the experience of all our customers is a challenge for us in those committees. So I think success for me of a Charter in action looks like this, and that is an organisation which embraces the Charter and has that embedded in every element of its dealings with the taxpayer and running through all of its sort of staff's consciousness. But also the fact that at the end, the board of the Revenue and Customs feels as though the Charter Committee has really challenged it, has really brought best practice into its thinking and made a practical difference to the outcome of the Charter and the service it gives to its customers. Thank you.
Elaine, thank you very much. you have shown us that a lot has changed since the Magna Carta, where we talked about the arbitrary authority of the despot. The UK tax administration doesn't behave anymore as a despot. Nevertheless, of course, the position of a taxpayer is not the same as the position of a tax inspector. There is not the same balance of power as in a contract. And that is also important if you look at the obligations mentioned in the Charter for taxpayers. You must be honest, keep us informed, we will work together. But of course, there are also situations where a taxpayer has a right to be silent, because he can be considered to be a suspect, and he is not, he should not incriminate himself. And where is the borderline? There's always, the tax administration has a lot of power compared to the individual taxpayer. Well, we'll have a look at that at the debate. Now I would like to give the floor to John Bivakwa. The floor is yours.
Hello, my name's John Bivakwa, and I'm an academic from Australia. And I've submitted a paper that, in academic style, goes into great length and detail on a lot of case law. I have dabbled in this paper, which is a bit of a danger, in jurisdictions outside of my own. So I've looked at Australia and then some of the Canadian and US and New Zealand case law, but I don't purport to be an expert in any of those jurisdictions other than my own. But all of that doesn't matter, because I'm going to do away with academic rigour, and I'm not going to discuss any of those cases. But what I'm going to do today, there's really two things I want to discuss in this paper. The first one is a potential problem I see, where we may be unwittingly creating tax exceptionalism in dealing with taxpayer complaints against tax officials, or taxpayer claims against tax officials, through the use of public policy, and this particular public policy that I'll discuss in a moment. And then I want to discuss or raise a few ideas I've had on how we might deal with that problem in a slightly more, I won't say scientific way, but perhaps a little bit more of a nuanced way. But I'll start by putting this, where this idea came from, or where my concerns come from, in a little bit of context. I've spent most of my academic research career interested in the ability of taxpayers to enforce the rights that they notionally have. So the ability of taxpayers to have practical relief. I noticed Peter said before, I think that we can all be friends, but we have to have rules, and I will take that a step further, that I think we need to have real remedies for taxpayers when those rules are broken. And so I've spent a lot of time looking at how taxpayer rights translate into real remedies, particularly where taxpayers seek compensation or forms of declaratory relief for breaches of their rights by tax officials. And what I've found in looking at those cases and considering those issues is some common themes, some common threads of public policy issues being used, coming up in some of these cases quite often, to deny taxpayers relief in situations where they might otherwise have had quite a strong case. And one of the issues that comes up quite frequently, and I've seen this across the jurisdictions I've looked at, is this concern about a chilling effect that imposing liability might have on tax officials. So I'll just explain what that is. Yes. There's a third thing I'm trying to do today is really overwork a pretty obvious pun, so excuse me for that. So what is the chill factor effect? Well, the chill factor effect is a concern of potential overreaction by a tax official, an over-defensive response in the event of claims by taxpayers being permitted against them. And it comes up in a lot of different contexts. It struck me when Elaine was talking about the UK Charter there before. She mentioned, healthful and efficient service and information provision as being key commitments, and you see this across the board in charters. Well, one of the concerns with the chill factor is that if tax officials are concerned that they might be sued at every turn, then they'll start to freeze up, they'll start to hesitate in providing that efficient service, that provision of information. So, for example, they mightn't provide information at all if it's seems particularly risky, or they might only provide that information after lots of time-consuming consideration and expensive legal advice to make sure that there's nothing wrong in it that they could be sued over. And there are lots of other manifestations that come up in the cases, right through to discouraging people from wanting to be tax officials at all. If I'm worried that I'm going to be sued, why would I want to become a tax official? And that's not a good thing. So there are a whole lot of ways in which the chill factor effect comes up. And there's some inherent logical appeal to that. You can see why it's attractive to a judge considering a case to say, well, gee, I don't want to risk these potential chilling consequences here by finding in favour of the taxpayer. But when you dig a little deeper, and this is what I've tried to do in my paper, to see whether this chill factor actually exists, and then whether in the tax context it exists, and if tax officials need that special treatment that Peter referred to before, I've come up pretty empty-handed, actually. So in terms of does it exist? Well, there's plenty of research over the years into chill factor effects and public officials generally, but it's pretty inconclusive. It swings in either direction. Some findings suggest that the chill factor effect is a real phenomenon and it's demonstrably true. In other situations, there is no such finding. For example, the most broad-reaching Australasian study found that public officials generally don't respond over-defensively, overwhelmingly don't respond over-defensively to adverse judicial determinations. In fact, they said that most officials view those findings as a valuable and instructive incident. So I'm not sure that, again, intuitively, but I don't see that being correct, but that's what's come out of the research by people who have actually looked at the issue. So there's at least some doubt here. And in the tax context, I can't find any tax-specific studies here. I can't find anything that actually considers whether or not tax officials are particularly prone to reacting over-defensively or not. I found plenty of commentary along the way. So, for example, some of the things that have come up, it seems from the commentary that the answer to whether tax officials deserve special protection here, whether they're prone to behaving over-defensively, depends on lots of things. So it depends on their level and their role within the organisation, and the extent to which they might be subject to personal liability. There are suggestions in some of the commentary that no, tax officials respond more to political pressures rather than economic pressures, perhaps. Even if you put all that aside, surely it will depend on the jurisdiction as well and the framework of obligations on tax officials in each jurisdiction and the approach, the culture within the organisation. And even if you were to get all that right, it's likely to change over time. So tax official behaviour, I don't think it's fair to say that it will remain constant over time. It might change, different attitudes might change over time. So the answer to these questions is a real not quite sure, it depends, which is quite unsatisfactory. But when I look at the case law, and this is my 10-second look at the case law, I'm finding that, and I'm going to skip this, I'm just showing these for the pictures really. That's my favourite. When I look at the case law, what I'm finding is, I think I'll leave it on the cat. What I'm finding is that judges, when they're considering taxpayer claims against tax officials, tend to either accept the chill factor effect as a real phenomenon, and that's the more common outcome, without really subjecting it to any real rigorous analysis, any rules of evidence or any real lengthy discussion, or equally they might reject it out of hand as well. And so what I'm thinking that we might be creating here is a situation of potential tax exceptionalism here, of treating tax officials in a special way, extending their immunity, perhaps unnecessarily, through relying on a phenomenon which we're not even sure that it exists. We definitely don't know whether it exists in a tax context. And even if it did, we're not quite sure. It's unlikely to be an even phenomenon anyway. It might be more prevalent in certain places, to certain types of officials, in certain actions. So all of that makes me a little nervous. And so this is really what I've come to in my paper. Oh, I've gone the wrong way. Hang on a moment. Just want to show the pictures again. There we go. Righto. As I said, I don't think you can deal with these sorts of issues in a scientific way, but I think from the cases, I've tried to extract little threads where they're there to give us some clues on how we might deal with this in a little bit more nuanced way anyway, to try and ensure that we're not unnecessarily treating tax officials as special through these spheres. The first one is perhaps we can delineate between cases where individuals might be potentially liable, personally, from claims against the revenue more generally. And the argument there goes that, well, look, if it's an individual, if I as an individual am likely to wear the bill if the claim proceeds and succeeds, then for self-preservation, I'm much more likely to act over-defensively in future when carrying out my role. On the other hand, against the revenue, big organisation, opportunity to spread the loss a little bit. Maybe it won't filter down to the lower level employees, the people dealing with tax-paying public. So perhaps there's less likely to be an over-defensive response, and we mightn't need to worry about it as much. On the other hand, though, you can be. I think that's too general as well, because if you think about it, when you look at the sorts of claims where a tax official might be personally liable, these are claims often that involve really flagrant breaches of taxpayer rights, malice, recklessness, and perhaps those things sure you might react over defensively, but in the long run, we want people to be fearful, or tax officials to be fearful of behaving in such a flagrantly offensive way. So, that argument could cut both ways. The second one, chilling effects and judicial uncertainty, is just a simple point that we perhaps, where a judicial outcome might create judicial uncertainty, so, for example, where it might create a precedent that goes well beyond established limits of liability, or where there's already in existence a comprehensive code but the case seems to go beyond, then perhaps we need to be particularly mindful of over-defensive responses. Because remember, it's about over-defensiveness, and over-defensiveness is far more likely where we're unsure of things. So there's uncertainty, you might go over the top in your response. So I think that's a valid one. The third one, policy operational matters. I raised that one because this policy operational distinction is a distinction that's familiar in all of the jurisdictions I've looked at, as delineating where immunity from suit should start and end for tax officials. So typically where tax officials are dealing with policy and discretionary matters, they should be immune from suit, is the view. Whereas on the other hand, if they're acting operationally, doing day-to-day functioning in a commercial sense, well, why should they be afforded special protection any more than a bank or an auditor in an accounting firm? So again, you can see that could be a good delineation to use as to when to give weight to these chill factor concerns. And the other one, the last point I'd make, is that in any event, even if you are going to consider chill factor effects or any public policy concern, I think you've got to consider the countervailing benefits, perhaps, particularly in the long run. So, for example, if taxpayers have confidence that if their rights are breached, they have a real remedy, then in the long run, perhaps they'll be more trusting of the revenue and more willing to comply, more likely to be friends. So perhaps, at least when we consider public policy effects like chill factor, we need to consider the balancing those. I'm not seeing that in the case law at the moment. So I think we could have that situation of tax exceptionalism, which is unwarranted. Thank you.
John, thank you very much for this very original approach of the topic of tax exceptionalism. You know, after BEPS, aggressive tax planning is more or less a taboo. But you have shown that an aggressive attitude of a tax advisor or a taxpayer might pay off. Because, yeah, and then you can doubt, is it tax exceptionalism or is it normal human behavior that tax authorities bend down and that they are over-defensive in their reactions. But I think it's something we should take care of. Now I give the floor to Alice and Richard for the final presentation. It's a combined presentation, so it will be very interactive. The floor is yours.
Thank you, Peter. And we have a really tough act to follow. Not only were the presentations that have preceded us really interesting, but everybody had a really cool European accent, and we are here with a pedestrian American accent. So while we're getting set up, our task today is to talk about taxpayer rights from an American perspective. And we approach this from two different disciplines. I'm a tax person, and Rick, who has long now been my collaborator as well as my colleague, comes from jurisprudence. And we have had a now long collaboration. We have part of what the work we've done has dealt with tax exceptionalism, and we discuss tax exceptionalism as it applies to taxpayer rights in the paper that is part of your materials for the conference. And I also discussed it in 2015 at the first International Taxpayer Rights Conference. But in the limited time that we have today, we want to talk about another aspect of taxpayer rights. And we want to do that because we think that there is an elephant in the room when we talk about taxpayer rights, at least from the U.S. perspective. And we think it is time to identify and challenge that elephant. So that's what we are intending to do today. The subject of taxpayer rights in the U.S. has been a topic of concern for at least 30 years. And nobody has championed it like Nina Olson has done. Nina was instrumental in the IRS's adoption of a Taxpayer Bill of Rights in June of 2014. And at the first Taxpayer Rights Conference in 2015, she took understandable and very deserved pride in announcing that legislation had been introduced to codify a Taxpayer Bill of Rights into the Internal Revenue Code. That happened, that the codification is in Section 7803A3, which is now a part of the law. And I would have expected that the combination of the IRS's adoption of a Taxpayer Bill of Rights, followed by the codification into the Internal Revenue Code, would have resulted in lots of scholarly and administrative commentary, and a plethora of articles would have been written. And yet, I think the tax bar and tax practitioners generally shrugged. And so the question is, why? Indeed, the day after the IRS's adoption of the Taxpayer Bill of Rights in 2014, there was one item published in Tax Notes, which is required reading for all tax folks, and everybody reads Tax Notes. And that item was an anonymous and highly critical letter addressing the question of the IRS's adoption of a Taxpayer Bill of Rights. And I want to discuss that letter because I think that the criticisms it makes points to that elephant and allows us to identify and challenge it. So the letter began by claiming that the IRS's adoption of a Taxpayer Bill of Rights was, quote, no more than a cynical move by the IRS to stave off further regulation by Congress. And the author of the letter went on to say that rights are like not really rights, and put the word rights in quotes, because, he or she said, the fact of the matter is that many of the enumerated rights are not actually rights, the IRS is not compelled to respect them, and the taxpayer has no legal remedy when they are violated. The letter went on to quote from Marbury versus Madison, the iconic constitutional law case in the United States, and took umbrage that in the letter's words, the IRS spin doctor's self-congratulatory claims that the IRS pronouncement is similar to the Constitutional Bill of Rights. And one could dismiss that letter as just more of the IRS bashing that has become all too common, unfortunately, in the United States. But we wanted to address it because we think that the letter highlights what we think is the elephant in the room as we discuss taxpayer rights, at least from a U.S. perspective. And that is the apparent absence of an enforcement mechanism, of a mechanism for making claims, receiving compensation, and in some ways operationalizing taxpayer rights. We think that it is wrong to say that the U.S.'s Taxpayer Bill of Rights is mere window dressing because it doesn't seem to provide affirmative mechanisms for compensation and enforcement, and we want to show why we think that's wrong.
So for purposes of this discussion, I want to assume that there are no direct remedies available in the Internal Revenue Code or through doctrines for enforcing the Taxpayer Bill of Rights that was adopted by Congress. And the question then is, if there are no, or if it's not, if at least it's not clear that there are directly available remedies for the failure of tax officials to respect those rights, what is the value of a Taxpayer Bill of Rights? Are they rights at all, or are they, as Alice has wondered, simply a window dressing? And I think one way of getting a handle on this is to focus on what I think of as a crisis of legitimacy in the tax system in the United States. There are a number of what I believe are deep sources of this crisis of legitimacy. One is tax exceptionalism. As Alice and I have argued in other papers, when you have this prevalent notion that tax is somehow separate from other fields of law, that it's different perhaps in kind from the rest of law, then many of the things the tax authorities do, many of their decisions become obscure. They look mysterious, and they are potentially illegitimate. Whereas if you saw what they did through the lens of ordinary principles of administrative law, that is, if you saw what they're doing as just law like any other field of administrative law, then what the tax officials do would seem readily explainable and justifiable. But I want to focus on another source of this legitimacy crisis. And this is what I believe is the case, that the tax system is not in the public's mind in the United States associated with principles of justice. When the government places burdens on citizens or persons generally that come into contact with the government, those burdens have to be perceived as just in order to be seen as legitimate. But I think tax is not perceived as just. It is not perceived as substantively just because the relationship between what the government takes in the form of taxes and what it gives back in the form of the things of values that are made possible by virtue of taxation, that relationship between what is taken and what is given is often obscure in our tax system. Moreover, tax is not perceived as procedurally just. The tax system for many taxpayers in the United States feels remote, it feels arcane, it feels oppressive, and it feels uncaring. The Taxpayer Bill of Rights, as codified in the Internal Revenue Code, responds to this issue of procedural justice, procedural fairness, by explicitly using the language of rights for the first time. Prior to the codification of the Taxpayer Bill of Rights in the Internal Revenue Code, there were certainly many obligations placed on the Secretary of the Treasury and other tax officials. But the language in the code that was the language of obligations, of duties. What has happened now with the codification of the Taxpayer Bill of Rights is those obligations and duties placed on tax officials have now been translated into the language of rights, so that what was seen initially as obligations are now seen as entitlements possessed by the taxpayer. Moreover, the language of rights has a particular resonance, a particular significance, a particular meaning in the United States political culture, in that the language of rights signals that these entitlements reflect the demands of justice, specifically in this case, procedural justice. When the language of rights is used, it is clear that the source of these rights is not in the positive law itself, but rather lies outside the positive law. It lies in justice itself.
But the problem I have with that argument is that it's still talking about words, and it's just words, and I'm still left with nice words and claims of justice, but no actual ability to enforce them, so I'm still left with either window dressing or lipstick or, pick your metaphor.
This is fun. Words can have practical significance. Words can have enormous practical significance. In this case, what is happening in the codification of the Taxpayer Bill of Rights is actually the combination of two different meanings. One is the one I was talking about a moment ago, the language of rights, and this notion that what we have in the Taxpayer Bill of Rights are entitlements that have their source in justice. But the fact that the form of the Taxpayer Bill of Rights is now codification, is now a statutory form, gives it an important additional expressive meaning, because now it becomes clear, because of the legislative form, that the Taxpayer Bill of Rights has the force of law. that they are legal rights. They're not just moral rights or rights emanating from justice, but they are legal rights, and so the law itself now stands for procedural justice. And when you combine those two things, when you combine the significance of the language of rights with the expressive meaning that flows from the form of codification, then that creates a robust normative basis for taxpayers to demand that those rights be respected and enforced. The codification of the Taxpayer Bill of Rights strengthens the taxpayer's position to insist that these demands of justice actually be satisfied by the actions of government officials, and that if they are not satisfied by the actions of officials, that the law provide remedies for their non-enforcement.
But that raises two additional concerns. So if Taxpayer Bill of Rights really does mean something, and we can overcome the chill factors that John talked about, have we perhaps gone too far? Because if it is the status of taxpayer that then provides access to all of these rights, doesn't that mean that that includes entities, corporations, partnerships, Microsoft, Google, Intel, Apple? And do they need rights? The tax shelter wars and the current issues of inversions and similar things suggest that it isn't those taxpayers that need rights. In fact, it is the tax system that needs protection from them.
All taxpayers are entitled to the rights that are enumerated in the Taxpayer Bill of Rights. Remember, rights reflect the demands of justice, and justice demands equality in the treatment of taxpayers. The question then is whether, because taxpayers or tax entities of the kind that you have been describing have particular wealth and particular power, whether that power and wealth makes them unequal in some way, so that it is just to give them less protection than ordinary taxpayers might get. So how could that be? How would it be that wealth and power makes it just to treat you less aggressively with the protection, give you less aggressive protection in terms of rights? Well, one possibility is sort of that in principle, wealthy, powerful taxpayers are less deserving of rights because they are less vulnerable to being treated wrongly by the tax officials. But that's clearly not true. I mean, Microsoft can be charged can be given an inaccurate tax bill just as easily as I can. But maybe it's a practical problem. Maybe the idea is that if you have wealth and power, then you are in a better position because you have greater resources to protect yourself. In that sense, Microsoft has an army of lawyers and others at its behest that it can protect itself from maltreatment by tax officials. But the problem there, it seems to me, is that all taxpayers, including the wealthy and the powerful, are vulnerable to changes in their situation, in their position. And if they lose their wealth, if they lose their power, then they no longer have the resources to protect themselves. The only way of ensuring that all taxpayers are treated justly is to aggressively, conscientiously protect them fully with the rights enumerated in the Taxpayer Bill of Rights.
Second issue or potential overbreadth is that, again, if it is just the status of taxpayer that is relevant, we're talking about the extraterritorial application of law. It is well known that the U.S. tax law does apply extraterritorially, but is it really right to be extending rights to folks whose only connection with the United States might be an investment made for pecuniary gain? Extraterritorial application of law is the exception in the U.S., not the rule, and so should we be extending that exception to taxpayer rights?
The government should treat all who come into contact with it with justice. I think it's important to keep in mind that the traditional rule against the extraterritorial application of law was developed to protect state sovereignty. The concern was that when the United States projects its law beyond its borders, it interferes with the sovereignty of other nations. But the United States does not interfere with the sovereignty of other nations when it extends procedural justice to the citizens and the residents of those nations.
So to conclude, since we do have to do that, I want to return to something that the Commissioner said when the IRS adopted the Taxpayer Bill of Rights in 2014. And what he said was that he wanted to stress the importance of having resources at the IRS to be able to conduct tax administration in accordance with taxpayer rights. And when I first heard that, I confess I sort of dismissed it as just another example of the commissioners, perpetually, begging Congress for more money in the face of Congress's continuing defunding of the IRS. But as I reflected on it later, it seems to me that there's a lot more to that statement. And so that's what I want to talk about. It seems to me that in the IRS's own adoption of a Taxpayer Bill of Rights and the Commissioner's discussion about administering the tax system in accordance with taxpayer rights, what the IRS is doing is that the IRS is taking upon itself the job of enforcing taxpayer rights. Taxpayer rights then become not something that is imposed on the IRS from the outside, but something that the IRS is undertaking as its job and its job to protect. And that brings us to a subject that we haven't talked much about yet, but which I think is vitally important, and that is the role of the Office of the National Taxpayer Advocate in the U.S. and of ombuds in other systems. Because it is in those offices that we see the agency itself standing for the protection of taxpayer rights. In the U.S., the National Taxpayer Advocate and her office is the Taxpayer Advocate Service, acts in a way as representatives of taxpayers. They don't act as taxpayer counsel, but they perform many of the services of counsel in representing the taxpayers when there are problems with the IRS. So, in other words, the Taxpayer Advocate Service gives Taxpayer Bill of Rights teeth. And those teeth, I think, have been sharpened substantially very recently in Nina's 2016 annual report, which is 3 volumes this year, and I highly recommend it. It's good reading. But one of the things that she does this year, which is vitally important, is that she has a taxpayer rights assessment. That is a report card of how the IRS is doing in respecting taxpayer rights, and that will become a standard feature of the report going forward. In addition, in identifying the 20 most serious problems that face taxpayers, for each of those, the report identifies which taxpayer rights are implicated by those problems. And that leads me to conclude with an observation of sort of the overriding import of the Taxpayer Bill of Rights and the work of the National Taxpayer Advocate and her office. And that is that it's a concrete expression of the importance of tax administration to the working of the tax law. It is a concrete reflection of the maxim that procedure is substance. And if that's right, and I think it is, I think I want to leave at least the academics in the audience with a challenge. If that's right, we need to start thinking about how we convey that procedure is substance when we teach the substance of the tax law. And so, thank you very much.
Alison, Richard, thank you very much for this overview of the pros and cons of the US situation on the Taxpayer Bill of Rights. It brings me to the question, what will be the influence of the new administration in the US on this topic, and especially the influence of your new president, because he might have some personal experiences with the IRS. Well, this opens the debate. We can have some questions and statements. We have 15 minutes for the debate. Please mention first your name, and then we will start the answering. Who would like to start? Is there a microphone? Yeah, please.
Hi, my name is Eric Nkawani. I come from Johannesburg, South Africa, Office of the Tax Ombudsman. I just want to ask one thing. Whose responsibility at the end of the day is it to ensure that the rights of taxpayers are put up there? Is it the Revenue Authority, or is it the Ombudsman or taxpayer advocate, whichever way?
Thank you. We take a couple of questions. Gentleman on the right.
Thank you. I'm Henk Elvers, and I'm a criminologist from Amsterdam. Criminologists are interested in dark numbers. That is, those crimes that we don't know that exist. The police register some, but not all. And in this context of this admirable panel today, I'm interested in the dark numbers of complaints of taxpayers that we don't know. Elaine Ben told us that there were 18,000 complaints in the UK, which is incredibly low, much better than Marks and Spencer's did, I'm sure. And that brings back the topic, is the tax charter or the tax bill of rights not something for tax professionals instead of for taxpayers? How many taxpayers are really aware, especially individual taxpayers, are really aware of the rights specified in a charter or a bill, and how often would they invoke these rights? My guess is that a large majority, let's say 90% of all complaints, is never being imagined by the taxpayers as having to do with a Bill of Rights at all.
Thank you. Nina?
I think the panel was just absolutely wonderful. I thought I would just talk a second about the experience of trying to get the IRS to adopt the Taxpayer Bill of Rights and what I had envisioned might transpire. The way I got the IRS to adopt it was to say it didn't create any new remedies that weren't otherwise in the law. So it wasn't like our Constitution, which is, and the Bill of Rights there, which is basically self-standing and self-executing in a way. It grants you these rights. To Hank's point, we had done a survey that showed that only about 47% of US taxpayers thought that they had rights before the IRS, and only 11% knew of what rights they were. And so I thought if we put this in a very clear way, they could at least understand generally that there were rights. And then what we did with those rights was we linked them, and you can go to our website, the taxpayeradvocate.irs.gov, to see how the specific statutory or administrative protections, the specific remedies, fall under each one of the 10 rights. But then Congress intervened, which was my secret strategy, to actually, put it into the Internal Revenue Code and charge the commissioner with ensuring that IRS employees protected those rights. A side issue was when it was just adopted by the IRS, I and my staff used the words in certain conversations, this is a violation of the right to a fair and just tax system. And the IRS would come back and say, it's not the law, therefore it's not a violation. So we came up with the thesaurus of words that we were able to use, like it's an infringement, it's an impingement, it's all sorts of stuff, but we didn't say violation. And then on December of 2015, we started to be able to say, this is a violation of law. And I think that brings the next phase in my stealth strategy in the US system, which is the courts, and this goes to John's point, that we're a common law system. So we now have in the law, these provisions, and the courts can then take those provisions, and as situations are presented to them, they can say, what the IRS did here is a violation of the right to be informed, a violation to the right to quality service. And that in itself creates a precedent that can be built upon in the next case and the next case, so that over time we can have development of what actually the right to quality service means.
Thank you. I take one more comment from the left side.
Yes. Thank you so much for a very exciting panel. My name is Lotta Björklund Larsson. I'm yet another academic, and I've been studying the Swedish tax agency. And I particularly liked that, Elaine Ben, when you said that the practices we apply within the HMRC. And I would like to ask you, and perhaps also to Nina, is that changing the revenue collector employees' views on how to treat taxpayers. What was the biggest challenge in practice, so to say?
Okay, thank you very much. Let's start with the first question. Whose responsibility is it to take care of the rights and obligations of taxpayers? Alice?
I want to suggest an equation that comes to me from the work that Rick and I have done. And that equation to me is that you need two things to come together. And if you put together the language of rights with a codification, the legislative imprimatur, the combination of those two things, we think, create a powerful normative basis for enforcement. And we believe that the combination sets up the kind of normative basis that I think courts would be able to build from.
Yeah, I would just add to that it seems to me that the form in which the Taxpayer Bill of Rights appears is critical. When the IRS in 2014 adopted the Taxpayer Bill of Rights, it expressed a commitment on the part of the IRS to respect those rights. But when that same language was codified, it became part of the Internal Revenue Code, it gave it the force of law in exactly the way that Nina was describing earlier. I would just add, by the way, to her comment about the Bill of Rights in the United States Constitution. One of the great debates in American constitutional theory is whether the Bill of Rights creates rights, grants rights, or is simply the enumeration of rights that existed prior to the Constitution itself. That is to say, to use language from another era, natural rights, rights rooted in justice. As is probably obvious, my own view of the matter veers more toward the notion that the source of these rights are justice, and I think the same is true of the Taxpayer Bill of Rights. I think the source of those rights is not in the codification itself, but rather in justice.
Thank you. Then we had a comment on the dark number of complaints, the anonymous taxpayers who do have very bad experiences, but how to make sure that they can benefit from these charters. Elaine.
Thank you, Hank. Yes, I would agree with you, and I would say perhaps 98% of the customers who are dissatisfied in some way will probably not go down the route of pursuing a formal complaint. So when I talked about our refreshed complaints ambition that the Charter kind of helped us develop, that was why we focused in on the sources of learning. So what is it that drives those complaints? What are the customer pain points, the things that really drive people who do feel so annoyed, irritated, desperate that they go down the route of making a complaint, because most people don't, you know. And the British, we tend not to complain too much. So, you know, we kind of, our nature is to sort of just let it ride, generally speaking. So we recognised that what we had to do was to really get under the skin of the things that people were complaining about and get to the root cause and fix those things in our systems. And that you know, that might be guidance and advice which people couldn't understand. It might be that our processes were really perverse and that different parts of our system didn't speak to one another, you know, a whole range of complaints. But that's why our new complaints ambition has pushed through every area of our organisation, that a source of a complaint is a true source of learning, and you have to act on it and really respond to that at the root cause.
Yeah,
just say one thing. I mean, I think my dad was a serial complainer, and I learnt at his knees, and I've become a bit of a complainer myself. So my wife thinks I'm a bit of a nutcase, and that's probably why I've got involved in taxpayer charter work. But I do think it's, and the UK experience has been up and down, and in the last 10 years has been up and down. And I've had, not with Elaine, but I've had terrible arguments with the senior people in HMRC about things which I thought they had nonsense beliefs about what a charter was all about. And you have to fight your corner, I think. And I think it's it's a matter in answer to the South African query. And I think and as I mentioned in my presentation, it's a joint effort. I don't think any one side can be the guardian of the purity of taxpayers' rights. It's a matter of the authority being committed to doing it, and there being mechanisms within the system to ensure that people have a legitimate and easy operable means of complaining, and that there are people like ombudsmen who will pick up the challenge if it's serious enough to be pursued. So I think it's a joint effort. It's not easy, and in the UK it's okay at the moment. I think the one thing that has changed, I think, in the UK in the last 2 years is that it's become a really important, critical element of the way HMRC sees itself as performing in terms of running the tax system. And there is an absolute positive commitment at the centre of HMRC, at the top level, as Elaine mentioned. It's the Charter Committee is now one of only 4 subcommittees of the board of HMRC. It's really central to what they do, how they see themselves performing and carrying out their duties, one of which is to uphold the rights of the taxpayer. Without that commitment, which we didn't have before, I was up and down for many years in terms of trying to get it to work sensibly and in a practical point of view. So, and people, generally speaking, don't like to engage with the tax system unless they have to. So, in theory, everybody ought to know that there's a taxpayers' charter and be, minded to exercise their rights under that charter. In practice, they don't want to get engaged with the tax system unless they have to. And then they need to have an easy way to do so, which will sort of address their issues in a way which is practical, simple, straightforward. And they come across a tax authority which is listening to what they have to say. And if they've got a legitimate complaint, is seriously going to do something to correct it and make it right. But that's not easy. And in some jurisdictions you do it by law. In other jurisdictions you do it by behaviours and charters and whatever. So that, there isn't one size fits all for all the world's countries, I'm afraid. And it's a lot of hard work, quite honestly. It's no easy task.
In any case, people should feel protected. That if they have a complaint, that they can put this complaint on the table without being challenged for other things. And I think that's also a very important issue. Last comment was, what are the biggest problems in the US with respect to the charter you faced? And of course, we all want to learn from your experiences. Can you reflect on this? What was the biggest challenge, or still is?
Boy, that's tough. The annual report lists 20 top 20 problems facing taxpayers, and so my instinct is really to cede the floor to Nina, who's in a much better position to answer that than we are. But I think that one significant problem really is getting the word out to the rank and file tax practitioners about the existence of taxpayer rights and promulgating the notion that taxpayers do have rights. I mean, Nina talked about the report that, showing that so relatively few people knew of taxpayer rights. And I think that that's a significant challenge, because if you don't know that you have rights, you can't even begin to think about enforcing them. And that's one of the reasons that I think that those of us who are academics really need to begin to step up and begin to consider issues of taxpayer rights as issues of the substance of taxation that we need to convey to our students as we try to teach them about the tax system.
This is a little abstract, but I think I think a big problem is cultural. The United States came into being in significant part as a revolt against what was perceived as unfair taxation. So the idea that tax is a suspicious activity, taxation is a suspicious activity, is deeply rooted in American culture. And I think it accounts to a great extent for the crisis of legitimacy and the disconnect between taxation and justice that we were talking about earlier.
Thank you very much. I would like to conclude this first panel. Now it's coffee time, but not before having thanked my fellow panelists for all your preparations and beautiful presentations. And please show your appreciation.